This installment of the Crucible examines the utility of medical apology laws, and the paper comes from a malpractice publication called the Physician Insurer in 2014. It's titled Legal Pitfalls of Medical Apology Laws, and I was the author. One of the core beliefs in the medical legal community is that we can avoid lawsuits by apologizing. If you make a mistake, you apologize, the patient will forgive you, and he won't sue you. Now, as you might expect, physicians are pretty skittish about this idea, so to help us along, most states have passed an apology law. These laws are supposed to protect us, but there are questions about how well they work. So I evaluated all 37 of these laws, and I summarized my findings in this paper. And the first thing I realized was that the mere existence of these laws is concerning. And I say that because if apologizing prevents lawsuits, then why do we need laws to prevent apologies from being used against us in court? If we apologized and the patient forgave us, which is what's supposed to happen, how did we wind up in court? So there's something amiss about this whole concept. The second concern relates to what these laws cover. They're called apology laws, but most of them don't cover apologies. Remember, an apology has two components. It's an expression of remorse accompanied by an admission of fault. Now that's to be distinguished from sympathy, which is an expression of remorse without any admission of fault. So if you say, "I'm sorry you're sick," that's sympathy. But if you say, "I'm sorry you're sick, it's my fault," that's an apology. And this distinction is important because most of these laws cover sympathy, but not apology, which means that they don't cover you if you admit fault or take responsibility. They're called apology laws, but most of them are just sympathy laws. They prevent lawyers from using sympathy against you. But how could a lawyer use sympathy against you? How does expressing sympathy to a sick patient make you look guilty of anything? It doesn't. And that means that most of these laws are completely useless because they prohibit something that no plaintiff lawyer is ever going to do anyway, which is to tell the jury that you were kind and compassionate and caring. Now, a few states have apology laws that cover actual apologies, and that sounds better. But these laws are so full of holes that they're not useful either. The first problem is that the protection doesn't apply unless certain conditions are met, and these conditions vary. In Vermont, verbal apologies are covered, but written ones are not. In Vermont and Washington, the apology has to occur within 30 days of the error. In South Carolina, the apology has to occur at a designated meeting called for the specific purpose of apologizing. All of the laws cover statements that are made to both the patient and the family, but the definition of family varies. Some states include grandparents, grandchildren, and adopted relatives, while others don't. Oklahoma includes stepfathers, but not stepmothers. And these details are important because if a non-covered person's present during the apology, you've lost the protection. But even if you walk that tightrope, you're still in danger because these laws don't seal the medical record, which means that once you tell the patient what you did, he can just get the record and take it from there. Nothing in these laws prevents him from doing so. Now, if you still want to apologize, you need to understand that your apology can also be used against you. You heard me correctly. Even when you qualify for protection, your apology can still be used against you, and there are multiple ways that this can happen. First, these laws don't prevent your hospital or your employer or the district attorney from using an admission of fault against you. And only Vermont's law prevents the State Board of Medicine from using an apology against you. These laws also have some technical shortcomings that we lawyers can exploit. The main one being that they don't place any limits on discovery. So even though your apology may not be admissible, it's still discoverable. And that's a problem because it means that a lawyer can ask you about it at your deposition. You have to answer, and then if you say anything contradictory at trial, the lawyer can use your previous testimony against you. And if you're interested in those details, I discuss them in my paper. I could go on, but I'll wrap it up with my paper's conclusion. And that is that these laws are nothing more than a trap which will snare any physician who mistakenly relies upon them. And if you'd like to read my paper, it's available in the link that accompanies this audio file. Thanks for listening.